Welcome to your complete Q&A guide for the Massachusetts Real Estate Salesperson exam. We mirror the real exam, then break down the right answer, the wrong ones, and the theory behind it all. In this session, we'll cover questions on estates and tenancies, agency and disclosure duties, contracts, title and easements, valuation, financing and fair housing, Massachusetts law and the board. Just a quick reminder, our website offers free study guides and practice questions designed to help you pass your Massachusetts exam. Be sure to check the link in the description below and grab everything you need to study smarter, not harder, so you can walk into that exam feeling confident and prepared. Alright, let's get started. Question 1. A person is given the right to use and occupy a home for the remainder of his lifetime, after which the property passes to a named third party. Which interest does he hold? Your options are A. An estate for years, B. A reversionary estate, C. A life estate, D. A fee simple absolute. Which one is it? Pause the video if you need more time. The correct answer is C. A life estate. C is correct because a life estate grants the right to possess and use property measured by someone's lifetime. When that life ends, ownership passes to the remainderman or returns to the grantor, depending on how the estate was created. A is wrong because an estate for years runs for a fixed, calendar-defined term such as a one-year lease, and it ends automatically on a set date. A lifetime measure is not a fixed term, so this label is wrong. B is wrong because a reversionary estate is the future interest kept by the grantor, not the present right held by the lifetime occupant. The person living in the home holds the possessory estate, not the interest waiting to return. D is wrong because fee simple absolute is the fullest unlimited ownership with no built-in ending point. Because this interest ends at death and then shifts to another party, it cannot be a fee simple absolute. Every estate in land can be understood by asking one question: what event ends it? Let's explore the life estate, the freehold estate whose duration is tied to a human life rather than a calendar. Estates split into two families. A freehold lasts an indefinite time and carries true ownership, while a non-freehold is a tenancy measured in fixed time with only a right to possess. The life estate is a special freehold measured not by a calendar but by someone's lifetime. When a life estate is created, the life tenant holds present possession, using and enjoying the property until the measuring life ends. Whoever receives the property afterward holds a future interest, either a remainder held by a remainderman or a reversion kept by the grantor. Don't confuse the life estate with its lookalikes. An estate for years ends automatically on a fixed calendar date. A fee simple absolute has no built-in ending point at all, but a life estate ends only when the measuring life expires. Remember, the occupant of a life estate always holds present possession, never the reversion waiting in the wings. Its duration is pinned not to a date, not to forever, but to a heartbeat. Question 2. A Massachusetts tenant rents an apartment under only an oral arrangement, with no written lease and no fixed end date. By operation of law, what kind of tenancy does this create? Your options are A. An estate for years, B. A tenancy at sufferance, C. A life estate, D. A tenancy at will. Take a second. Which answer would you pick? The correct answer is D, a tenancy at will. D is correct because in Massachusetts, an interest in land created without a signed writing has the effect of a tenancy at will. The oral, indefinite arrangement creates a tenancy at will, terminable by proper notice from either party. A is wrong because an estate for years runs for a fixed term with a definite end date and ends automatically. An oral, open-ended arrangement lacks a fixed term, so it forms a tenancy at will rather than an estate for years. B is wrong because a tenancy at sufferance arises when a tenant holds over after a right to possess has ended. This tenant occupies with the landlord's consent under an oral deal, which is a tenancy at will, not sufferance. C is wrong because a life estate is ownership measured by a person's lifetime. A renter under an oral arrangement holds a possessory tenancy, not an ownership estate tied to anyone's life. Let's dig into one of the trickiest landlord-tenant categories on the exam, the tenancy at will. The law's default rule for informal rentals. A tenancy at will has no fixed end date and continues only as long as both sides agree. Either party can end it by giving proper notice, and it typically springs up whenever a rental is handshake only, with no signed lease and no set term. Picture a landlord renting the second floor unit of a triple-decker on a handshake, with rent due monthly and no paperwork signed. That tenant holds a tenancy at will, and if the landlord wants it to end, he can't just change the locks. He must serve a proper notice to quit. Examiners love blurring these four together. Tenancy at will means consensual, open-ended occupancy. Tenancy at sufferance means holding over without consent after a lease ends. An estate for years has a fixed term that expires automatically with no notice needed, and a life estate is an ownership interest measured by a lifetime, not a mere tenancy. Keep two questions straight. Was there consent or is this a holdover? And was there a fixed term or none at all? Answer those and the four estates stop blurring together. Question 3. Under a Federal Fair Housing Act exemption, an owner who lives in a small multi-family building and rents the other units may be exempt. The exemption applies to owner-occupied buildings of how many units? Your options are A. Up to 2 units, B. Up to 3 units, C. Up to 4 units, D. Up to 10 units. Before I reveal it, which one do you think is right? The correct answer is C. Up to 4 units. C is correct because the federal exemption, sometimes called the Mrs. Murphy exemption, applies to owner-occupied buildings of up to 4 units. It is narrow and never permits discriminatory advertising or the use of a broker to discriminate. A is wrong because 2 units is the limit under the narrower Massachusetts owner-occupied exemption, not the federal one. The federal version reaches owner-occupied dwellings holding as many as 4 separate units. B is wrong because 3 units does not match the federal threshold, since the federal owner-occupied exemption extends to 4-unit dwellings. A 3-unit figure understates the federal limit by a single unit. D is wrong because 10 units is far beyond any owner-occupied fair housing exemption. The federal version stops at 4-unit dwellings and never reaches a building as large as 10 units occupied by its owner. Fair housing law sets a broad federal floor against discrimination, but Congress carved a few narrow exemptions into it. One of the most tested is the owner-occupied exemption, nicknamed after a hypothetical widow renting rooms in her own home. The Federal Fair Housing Act bars housing discrimination on protected characteristics, but it exempts the resident owner of a very small building. Congress reasoned that someone sharing their own living space deserves associational freedom. A commercial landlord does not. Picture a 4-unit building where the owner lives in 1 unit and rents out the other 3. This is the exact structure the federal exemption was written for. The exemption is narrow in 3 crucial ways. First, the building cap is 4 units, not 3, not 10. Second, discriminatory advertising is never allowed, exemption or not. Third, the exemption vanishes the moment a licensed broker enters the transaction. Massachusetts narrows the federal rule further, exempting only 2 family owner-occupied dwellings instead of 4. But in both jurisdictions, discriminatory advertising stays illegal and hiring a broker closes the exemption completely, since a licensed agent can never take part in discriminatory rentals. Question 4. A property manager collects rents and tenant deposits belonging to the owner and tenants. How must the manager generally handle these funds belonging to others? Your options are: A. Mix them with the manager's own money. B. Keep them as the manager's fee. C. Spend them on personal expenses. D. Hold them separate in a trust account. What's your answer? Commit to one before I continue. The correct answer is D. Hold them separate in a trust account. D is correct because funds belonging to others must be held separately in a trust or escrow account, not mixed with the manager's own money. Keeping client funds segregated and accounted for protects the owner and tenants and is a core fiduciary duty. A is wrong because mixing client funds with the manager's own money is commingling, which is prohibited. The manager must keep others' funds separate, so blending them into personal accounts violates the duty. B is wrong because treating tenant and owner funds as the manager's fee is conversion, a serious breach. These funds belong to others and must be held in trust, not claimed as the manager's compensation. C is wrong because spending client funds on personal expenses misuses money that belongs to others. The manager must safeguard these funds in a trust account, never divert them for the manager's own purposes. When someone handles money that belongs to other people, the law imposes a strict duty about exactly how that money must be held. The core requirement is segregation. Client funds must sit in a trust or escrow account, entirely apart from the manager's own money, with records showing exactly whose money is whose. 3 violations show up as wrong answers on the exam: commingling, which mixes client and personal funds even briefly; conversion, treating client money as the agent's own; and outright personal spending, the plainest form of conversion. Picture the trust account as a walled vault. Tenant deposits and owner funds sit inside together, completely sealed off from the manager's personal account, protected even from the manager's own financial troubles. The trust account isn't a courtesy, it's a required structure, and failing to keep funds separate is itself the breach, even if not a single dollar ever goes missing. Question 5. Massachusetts has an owner-occupied exemption from some fair housing rules that is narrower than the federal version. The Massachusetts owner-occupied exclusion generally applies only to a building of how many units? Your options are: A. A 2-family owner-occupied dwelling. B. A 4-family owner-occupied dwelling. C. A 6-family owner-occupied dwelling. D. Any owner-occupied building. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is A. A 2-family owner-occupied dwelling. A is correct because the Massachusetts owner-occupied exclusion generally reaches only a 2-family dwelling whose owner occupies 1 unit and rents the other. It is narrower than the federal 4-unit exemption and never excuses discriminatory advertising or using a broker. B is wrong because 4 units is the federal owner-occupied threshold, not the Massachusetts one. The state exclusion is narrower, applying generally to an owner-occupied 2-family dwelling rather than to a building of 4 units. C is wrong because 6 units exceeds both the state and federal owner-occupied exemptions by a wide margin. The Massachusetts exclusion is limited to a 2-family owner-occupied dwelling, which is far smaller than a 6-unit building. D is wrong because the exemption does not reach any owner-occupied building of any size. Massachusetts limits it to a 2-family dwelling, so larger owner-occupied buildings remain fully covered by the state fair housing law. Layered legal systems can produce a surprising result. State law can be stricter than federal law, and when it is, the stricter rule wins. The Federal Fair Housing Act allows an owner-occupied exemption for buildings up to 4 units, but Massachusetts narrows that to just 2 units. Neither version ever excuses discriminatory advertising, and neither survives if a broker or licensee is involved. Picture an owner living on the first floor of a two-family house, renting out the second floor unit alone, without any advertising or broker involved. That owner may qualify for the state's narrow exclusion. Exam traps use the federal number, 4 units, as a tempting wrong answer, or an oversized number like 6 units that fails under both systems. In Massachusetts, the correct ceiling is always 2 units. Remember, federal and state exemptions are parallel but different. 4 units federally, 2 units in Massachusetts, and the stricter state line always controls within the Commonwealth. Question 6. A seller tells his listing agent in confidence that the basement floods and asks the agent to keep it secret. A buyer is about to make an offer. What must the agent do about the flooding? Your options are A. Keep it secret to protect the seller. B. Disclose it only if the buyer asks. C. Disclose the known material defect. D. Refer the buyer to the seller. Which would you go with? Lock it in before the reveal. The correct answer is C. Disclose the known material defect. C is correct because a licensee must disclose a known material defect, such as a flooding basement, even when the seller asks that it be kept secret. Confidentiality protects the seller's negotiating information, not the concealment of defects that affect the property. A is wrong because keeping a known material defect secret to protect the seller violates the licensee's disclosure duty. Confidentiality covers bargaining strategy, not hidden conditions, so the flooding must be revealed despite the seller's wish. B is wrong because waiting for the buyer to ask does not satisfy the affirmative duty to disclose material defects. The agent must reveal the flooding whether or not the buyer raises the subject, since concealment would be deceptive. D is wrong because merely referring the buyer to the seller passes off a duty the licensee personally owes. The agent must disclose the known defect directly rather than leaving it to a seller who wants it hidden. A seller's agent owes loyalty and confidentiality to the seller, but that same agent can never help hide a known physical defect from a buyer. Understanding exactly where confidentiality ends and honesty takes over is the key to this rule. Confidentiality covers the seller's bargaining information, the lowest price the seller would accept, the seller's motivation, and the seller's financial pressure. Those facts the agent must guard closely. A known material defect, like a flooding basement, is different in kind, and hiding it is deception, not negotiation. The duty is affirmative, so it is not enough to answer truthfully only if asked, to deflect the buyer back to the seller, or to hide behind the license itself. Each of these half measures fails the standard because the obligation to disclose a known material defect is personal to the agent who knows it. Picture the listing agent at the kitchen table. The seller has confided that the basement floods every spring and asks the agent to say nothing. When a buyer is preparing an offer, the agent must disclose the flooding directly, because the duty of honesty to the buyer cannot be waived by the seller's request for secrecy. Protecting negotiating information is required. Concealing a known material defect is never allowed. In Massachusetts, Chapter 93, A adds extra teeth, treating concealment as a deceptive act, so the safe course is always disclosure. Question 7. A licensee wants to buy a listed property for himself or for a close relative while involved in the transaction. Before proceeding, what must the licensee do to comply with the conflict of interest rules? Your options are A. Nothing since he is licensed. B. Simply mention it verbally at closing. C. Avoid telling the other party. D. Disclose it in writing and get acknowledgement. Don't overthink it. Which one feels right? The correct answer is D. disclose it in writing and get acknowledgement. D is correct because a licensee with a personal financial interest, including a relative's interest, must disclose that interest in writing to all parties and obtain their written acknowledgement. Full written disclosure and consent are both required before proceeding with the transaction. A is wrong because being licensed does not excuse the licensee from the disclosure duty. A personal financial interest must be revealed in writing to all parties with their written acknowledgement before the licensee may proceed. B is wrong because a passing verbal mention at the closing does not satisfy the rule. The conflict must be disclosed in writing in advance and acknowledged in writing by the parties, not merely raised orally at the last moment. C is wrong because concealing the interest is exactly what the conflict of interest rule forbids. The licensee must affirmatively disclose the conflict in writing and obtain written acknowledgement, rather than hide it from the other party. Self-dealing threatens agency relationships whenever an agent gains personally from a deal, so real estate law demands a strict response before an interested licensee can proceed. A conflict of interest arises whenever a licensee's personal financial interest could compete with the duty owed to the parties. Sign what is full equal. This includes the licensee buying for himself, a spouse, a child, or a business partner or relative whose gain benefits him. The law demands three things together: written disclosure of the interest, written acknowledgement from all parties, and both delivered before the transaction proceeds. Picture a listed property where the seller doesn't know the buyer is the listing agent's brother. Before the deal can move forward, the agent must put that relationship on paper and secure everyone's signed acknowledgement. Remember, silence, a verbal aside, or the license itself are never enough. Only written disclosure and written acknowledgement made before proceeding satisfy the rule. Question 8. A lender hires a professional to provide an independent, supported opinion of a property's market value as of a specific date. What has the lender ordered? Your options are A. An appraisal, B. A comparative market analysis, C. A home inspection, D. A title search. Got a guess? Lock it in. The correct answer is A. An appraisal. A is correct because an appraisal is an independent, professionally supported opinion of value as of a stated date. Lenders rely on it to confirm that a property offers adequate collateral before they approve a mortgage loan. B is wrong because a comparative market analysis is a licensee's opinion of likely selling price drawn from comparable sales. It guides pricing but is not the independent, formally supported valuation a lender orders from a credentialed appraiser. C is wrong because a home inspection evaluates the physical condition of a property's systems and structure. It reports defects and needed repairs rather than estimating market value, so it answers a question different from the lender's. D is wrong because a title search examines public records to trace ownership and reveal liens. It establishes the condition of title, not the property's worth, so it cannot supply the value opinion the lender requires. Before a lender approves a mortgage, someone has to answer one critical question: what is this property actually worth? That answer comes from a very specific document, the appraisal. An appraisal is an independent, professionally supported opinion of a property's market value as of a specific date. Independent means the appraiser has no stake in the outcome. Supported means the value rests on analyzed data like comparable sales, and the date fixes that value to one moment in time. Picture the appraisal report itself. It states a market value opinion, ties that opinion to an effective date, backs it with comparable sales analysis, and closes with the appraiser's certification of independence. Every one of these elements exists so the lender can trust the number. It's easy to confuse the appraisal with other reports in a transaction, but each answers a different question. The appraisal confirms market value. A CMA estimates a likely selling price. A home inspection checks physical condition. And a title search verifies ownership and liens. Remember, the appraisal is the lender's reality check, acteken mee, an independent, supported opinion of value that protects the loan's collateral, not a sales pitch. Question 9. A Massachusetts owner begins renting a unit as a short-term rental. The law requires the operator to carry a minimum amount of a particular protection for each short-term rental. What is required? Your options are A. Flood insurance on the building. B. Title insurance for the guest. C. A performance bond. D. $1 million in liability insurance. Which one is it? Pause the video if you need more time. The correct answer is D. $1 million in liability insurance. D is correct because a short-term rental operator must carry at least $1 million in liability insurance for each short-term rental. A hosting platform's coverage of equal or greater amount can satisfy the requirement, and the operator should notify the homeowner's insurer. A is wrong because flood insurance protects against flood damage and is not the short-term rental requirement. The law mandates a set minimum of liability insurance, not flood coverage, for each short-term rental unit. B is wrong because title insurance protects against defects in property ownership and has no role in short-term rentals. The operator must carry liability insurance, not a title policy protecting the guest. C is wrong because a performance bond guarantees completion of an obligation, typically in construction. The short-term rental rule requires liability insurance, not a bond, to protect against harm to others during a stay. Short-term rentals booked through online platforms blurred the line between a private home and a small hotel, slipping past the rules that normally govern lodging until Massachusetts stepped in with a registration and insurance framework. Massachusetts requires each short-term rental operator to carry at least $1 million in liability insurance, covering injuries or property damage guests suffer during a stay. This requirement attaches to every rental the operator runs, and it can be satisfied instead by the hosting platform's own equal or greater coverage. Picture the rental home itself. Either the operator's own policy or the platform's equal or greater coverage must stand behind it, because an ordinary homeowner's policy usually excludes business-style use. Whichever party provides it, $1 million in liability protection must cover that property for every stay. The wrong answers protect against entirely different risks. Flood insurance covers flood damage to the building, title insurance covers defects in ownership, and a performance bond guarantees completion of a construction obligation. None of these protects an injured guest, which is exactly what the law demands. Remember the signal words, short-term rental, Massachusetts, minimum amount, and per rental, they point to $1 million in liability insurance, protecting guests and safeguarding the operator's solvency against the risk of hosting strangers. Question 10. When real estate is sold and the deed is recorded in Massachusetts, a state transfer tax based on the sale price must be paid. Who customarily bears responsibility for paying this deed's excise? Your options are A. The buyer, B. The lender, C. The seller, D. The closing attorney. Take a second. Which answer would you pick? The correct answer is C. The seller. C is correct because the deed's excise, the Massachusetts transfer tax, is paid by the seller, the party making the deed. It is collected through excise stamps at the registry when the deed is recorded at the time of transfer. A is wrong because the buyer pays many closing costs, but the deed's excise is the seller's charge. As the party conveying title and making the deed, the seller is responsible for the transfer tax rather than the buyer. B is wrong because the lender finances the purchase and does not pay the transfer tax. The deed's excise falls on the seller, who is the one making and delivering the deed to the buyer at closing. D is wrong because the closing attorney may collect and remit the excise at recording, but does not bear the cost. Responsibility for paying the deed's excise rests with the seller as the grantor of the deed. Every time property changes hands in Massachusetts, the state collects a transfer tax when the deed is recorded. A classic exam point is simply knowing who customarily pays it. The deed's excise is a rate applied to the consideration paid for the property, collected through excise stamps affixed when the deed is recorded at the registry. Because it's tied to recording, it's sometimes called a stamp tax. Picture the seller conveying a home for a stated price. The closing attorney computes the excise on that consideration, deducts it from the seller's proceeds, buys the excise stamps, and records the deed at the registry. The buyer pays many closing costs, but not the excise. The lender finances the purchase and pays no transfer tax. The closing attorney handles the mechanics, but is just a conduit, not the taxpayer. The excise belongs to the seller, the one conveying title. The cleanest way to remember it, the one who conveys is the one who pays. That's the seller, not the buyer who receives, not the lender who finances, and not the attorney who merely remits. Question 11. At the signing of the first written contract to purchase a home, Massachusetts requires that the buyer receive a particular educational item about a common pre-purchase step. What must be provided? Your options are A copy of the seller's deed, B, a home inspection consumer brochure, C, a title insurance policy, D, a municipal lien certificate. Before I reveal it, which one do you think is right? The correct answer is B, a home inspection consumer brochure. B is correct because at the signing of the first written contract to purchase, the licensee must give the buyer the home inspection consumer brochure. It educates the buyer about the inspection process so the buyer can make an informed choice. A is wrong because a copy of the seller's deed is not the item required at this point. The mandated handout is the home inspection brochure, which informs the buyer about inspecting the property, not about the chain of title. C is wrong because a title insurance policy is issued later through the title process, not handed over with the offer. The required educational item at the first written contract is the home inspection brochure. D is wrong because a municipal lien certificate reports unpaid taxes and is gathered during the closing process. It is not the consumer brochure the licensee must provide when the buyer signs the first written contract. Buying a home is a huge decision, and Massachusetts law makes sure buyers aren't left in the dark about one crucial step, getting the property inspected. The required item is the home inspection consumer brochure, and it must be handed over the moment the buyer signs the first written contract to purchase. Often the offer to purchase. The licensee, as the professional present at signing, carries that duty. The exam tests whether you can separate this brochure from other paperwork. The deed concerns chain of title. The title insurance policy arrives later in the title process, and the lien certificate is gathered during closing. Only the brochure is tied to that first signature. Picture a buyer sitting down to sign an offer to purchase. Right then, the licensee places the home inspection brochure in their hands, so the buyer can weigh whether to include an inspection contingency before it's too late. Remember the pairing: the home inspection brochure, delivered by the licensee at the signing of the first written contract to purchase, so buyers enter the deal informed, not blindsided. Question 12. A licensed Massachusetts salesperson wants to know how often the license must be renewed to stay valid. Generally, how often is a real estate license renewed? Your options are A, every 6 months, B, once every 5 years, C, only once permanently, D. Every 2 years. What's your answer? Commit to one before I continue. The correct answer is D. Every 2 years. D is correct because a Massachusetts real estate license is generally renewed every 2 years, with renewal occurring on the licensee's birthday and without retaking the examination. Keeping the license current requires timely renewal at each 2-year cycle. A is wrong because renewing every 6 months is far too frequent for a real estate license. The license runs on a 2-year cycle, renewed on the licensee's birthday, rather than being renewed twice each year. B is wrong because a 5-year renewal cycle does not match the law. Massachusetts renews the real estate license every 2 years, on the licensee's birthday, so a 5-year interval is much too long. C is wrong because a license is not granted permanently after a single issuance. It must be renewed every 2 years to remain valid, so the idea of a one-time permanent license is incorrect under the law. A professional license isn't permanent. Indeed, can say it's a privilege that must be renewed on a set schedule. And Massachusetts real estate exams love to test exactly how that schedule works. In Massachusetts, both salesperson and broker licenses renew every 2 years, and that renewal falls on the licensee's own birthday. Renewing keeps the license active, but letting it lapse means losing the legal authority to practice until it's restored. And importantly, renewal never requires retaking the exam. Picture the license itself as a document carrying its own built-in reminders. The 2-year cycle sets the rhythm, the birthday marks the trigger, and meeting the renewal requirements, not a new exam, keeps everything current. Exam writers build wrong answers from tempting but incorrect intervals. 6 months is far too frequent. 5 years is too long and belongs to other credentials. And a permanent license contradicts the whole idea of renewal. The real answer is 2 years. Hold on to this. A real estate license is a recurring privilege, not a permanent possession, renewed every 2 years. On the birthday shall never forget. Question 13. A municipality divides its territory into districts and sets rules for the permitted uses, building heights, and lot sizes within each district. Which land use control is the municipality applying? Your options are A. Zoning, B. A deed restriction, C. Eminent domain, D. A restrictive covenant. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is A. Zoning. A is correct because zoning is the public regulation that divides a community into districts and dictates permitted uses, densities, and dimensional limits. Setting use categories and lots and height rules across districts is the core function of zoning. B is wrong because a deed restriction is a private limitation placed in an individual deed by a grantor. It binds particular parcels by private agreement, unlike a town-wide system of districts imposed by public law. C is wrong because eminent domain is the power to take property for public use with compensation. It transfers ownership for projects like roads and does not set the use and dimensional rules that zoning establishes. D is wrong because a restrictive covenant is a private promise limiting land use, often among lots in a subdivision. It arises from private agreements rather than from a municipality dividing the whole community into regulated districts. Government has several tools for regulating private land, but the broadest and most tested is zoning. Zoning is a municipality's exercise of the police power to divide its territory into districts and control what gets built where. For every district, a zoning ordinance prescribes permitted uses, building heights, minimum lot sizes, and other density and bulk rules. This keeps incompatible uses from colliding and gives the whole community control over its physical character and growth. Don't confuse zoning with its lookalikes. A deed restriction is a private limit a grantor writes into one deed, and a restrictive covenant is a private promise a developer imposes across a subdivision, both enforced among owners, not by public law. Eminent domain is public like zoning, but it transfers ownership through a taking with just compensation rather than setting use rules. Picture a town whose zoning ordinance carves its land into a single-family district, a multi-family district, a business district, and an industrial district. A landowner in the single-family district can build a house, but not a warehouse, because the public ordinance assigns uses by district, binding every owner in that area alike. Remember the divide. Zoning is public regulation across an entire district. Deed restrictions and covenants are private limits on particular parcels, and eminent domain is a public taking with compensation. When a stem describes town-wide use and dimensional rules set by public authority, the answer is zoning. Question 14. Several competing brokerages secretly agree to charge sellers the same commission rate, so none undercuts the others. Which body of law does this agreement most directly violate? Your options are A. Fair housing law, B. The statute of frauds, C. Antitrust law, D. The Recording Act. Which would you go with? Lock it in before the reveal. The correct answer is C. Antitrust law. C is correct because an agreement among competing brokerages to fix commission rates is price fixing, a violation of antitrust law. Commissions must be set independently and remain negotiable, so colluding to set a common rate is illegal. A is wrong because fair housing law prohibits discrimination based on protected characteristics in housing transactions. It does not address competitors agreeing on prices, which is an antitrust concern rather than a fair housing violation. B is wrong because the statute of frauds requires certain contracts, such as land sales, to be in writing. It governs the enforceability of agreements, not collusion among competitors to fix the commission rates they charge sellers. D is wrong because the Recording Act governs how documents are recorded and the priority of competing interests. It has nothing to do with competitors conspiring to set uniform commission rates, which antitrust law forbids. Understanding why commission price fixing is a federal antitrust violation, not a housing law issue. Antitrust law prohibits agreements that unreasonably restrain competition, and price fixing is its clearest target, an agreement among competing firms to set, raise, or stabilize prices. When brokerages secretly agree to charge the same commission rate, they replace independent pricing with a cartel, and that agreement is illegal in itself, regardless of whether the price was reasonable. Picture several brokerages quietly agreeing to charge sellers the same commission percentage so no one undercuts the others. That coordination replaces each firm's independent pricing decision, and the seller who could have negotiated a lower rate is denied that chance. The exam tests whether you can separate antitrust from lookalike laws, fair housing bans, discrimination. The statute of frauds requires written contracts. The Recording Act governs priority among recorded interests, and only antitrust law addresses competitors fixing prices. Remember the signal. Competing brokerages plus a secret agreement on price always points to antitrust law, because commissions must be set independently and stay negotiable. Question 15. The Massachusetts State Sanitary Code sets minimum standards for rental housing. During the heating season, what does the code require an owner to provide? Your options are A. Adequate heat to a minimum temperature, B. Central air conditioning, C. Free cable television, D. A washer and dryer in each unit. Don't overthink it. Which one feels right? The correct answer is A. Adequate heat to a minimum temperature. A is correct because the state sanitary code requires owners to provide adequate heat to a minimum temperature during the heating season. This habitability standard ensures rental units stay warm enough for safe occupancy through the colder months. B is wrong because the code does not require central air conditioning. It mandates adequate heat during the heating season, not cooling. So air conditioning is not a sanitary code requirement at all. C is wrong because free cable television is an amenity, not a habitability standard. The sanitary code addresses essentials like heat and water, not entertainment services, so it does not require cable. D is wrong because in-unit laundry is a convenience the code does not mandate. The sanitary code focuses on basic fitness for habitation, such as heat, rather than requiring a washer and dryer in every unit. Massachusetts law sets a baseline for livable rental housing, called the State Sanitary Code, and heat is its most commonly tested requirement. The Sanitary Code sets minimum standards for fitness for human habitation, requiring owners to provide adequate heat during the heating season, keep the unit at a minimum temperature, and uphold this duty regardless of what the lease says. During the heating season, an apartment's furnace must keep the living space at or above the code's minimum temperature, monitored by the thermostat. If it fails, the tenant can report the owner to the local Board of Health for enforcement. The code draws a clear line between essentials and amenities. Heat, water, and safe wiring are required for basic habitability, while air conditioning, cable TV, and in-unit laundry are comforts the code never mandates. Remember the contrast. The sanitary code guarantees a dwelling fit to live in, not one loaded with comforts. Adequate heat in winter is the classic essential, not an amenity. Question 16. Two cooperating brokers dispute which earned the commission on a sale. Resolving it often turns on which broker set in motion the uninterrupted chain of events leading to the sale. This concept is called what? Your options are A. Procuring price, B. Liquidated damages, C. Procuring cause, D. Specific performance. Got a guess? Lock it in. The correct answer is C. Procuring cause. C is correct because procuring cause identifies the broker whose efforts set in motion the uninterrupted chain of events that led to the sale. It determines which broker earned the commission, and disputes are often resolved through association arbitration. A is wrong because procuring price is not a recognized real estate term at all. The concept that decides which broker earned the commission is procuring cause, the broker whose efforts effectively brought about the completed sale. B is wrong because liquidated damages are a pre-agreed sum that compensates for a breach of contract. They measure a buyer's or seller's default, not which of two cooperating brokers is entitled to the commission on a sale. D is wrong because specific performance is a court order compelling a party to complete a contract. It is a remedy between buyer and seller, not the test for deciding which cooperating broker earned the commission fee. When two cooperating brokers both claim a commission, the industry resolves the fight using a single test, procuring cause. Procuring cause traces the commission to the broker whose efforts set the deal in motion and carried it, without interruption, all the way to closing. If that chain breaks and a different broker independently completes the sale, the fee can shift to them instead. Picture the transaction as a chain: introduction, continuous effort, and the completed sale, all linked without a break. If that link snaps and the buyer wanders off, a second broker who independently restarts the sale can become the new procuring cause. Exam distractors often confuse procuring cause with unrelated remedies. Liquidated damages is a pre-agreed sum for a breach, and specific performance is a court order between buyer and seller. Neither decides which broker earned the fee. Disputes over procuring cause are typically settled through arbitration within a real estate association, not the courts. Watch for two cooperating brokers, a commission dispute, and the phrase set in motion an uninterrupted chain of events. That combination almost always points straight to procuring cause. Question 17. A licensed broker fully earns a commission, but the seller refuses to pay. The broker wants to know whether Massachusetts gives him a lien on the property to secure the unpaid fee. What is the answer? Your options are A. Yes, a broker's lien attaches. B. Yes, through a mechanic's lien. C. Yes, after recording the listing. D. No broker commission lien exists. Which one is it? Pause the video if you need more time. The correct answer is D. No broker commission lien exists. D is correct because Massachusetts provides no broker's commission lien. A broker who is not paid must sue on the listing contract as an unsecured creditor because no statute lets the unpaid commission attach as a lien against the property. A is wrong because no statute creates a lien that lets an unpaid commission attach to the seller's real estate. The broker's recourse is a breach of contract action, so a self-executing broker's lien is not available in the Commonwealth. B is wrong because the mechanic's lien law secures those who supply labor and materials to improve property. Brokerage services are not construction work, so a broker cannot convert an unpaid commission into a mechanic's lien. C is wrong because recording a listing agreement does not give it lien status against the property. The listing is a service contract, and filing it changes nothing, leaving the broker to pursue payment through a lawsuit. In Massachusetts, an unpaid real estate broker cannot place a lien on the property to force payment of a commission. Let's understand why and what recourse actually exists. A lien is a security interest, a claim against property that lets a creditor reach the property if a debt goes unpaid. It secures the debt, allows the creditor to reach the property, and even follows the property through a sale. The difference between secured and unsecured claims is huge. A secured creditor can force a sale or be paid from proceeds. An unsecured creditor only holds a right to sue. Massachusetts gives brokers no lien, so they stand as unsecured creditors who must sue on the listing contract. A mechanic's lien protects contractors and suppliers who improve real property with labor or materials. Brokerage services don't qualify, and simply recording the listing agreement doesn't transform it into a lien either. It's still just a service contract. Earning a commission and securing a commission are different things. In Massachusetts, the broker's only remedy is a lawsuit on the listing contract, not a lien against the property. Question 18. A broker representing a seller must follow lawful instructions, keep the client's information private, account for funds, and put the client's interests first. These obligations are collectively known as what? Your options are A. Antitrust duties, B. Fiduciary duties, C. Disclosure exemptions, D. Statutory liens. Take a second. Which answer would you pick? The correct answer is B. Fiduciary duties. B is correct because an agent's fiduciary duties include obedience, loyalty, disclosure, confidentiality, accounting, and reasonable care. Following lawful instructions, protecting client information, accounting for funds, and prioritizing the client's interests are the core duties owed in agency. A is wrong because antitrust duties involve avoiding illegal agreements such as price fixing among competitors. They protect competition in the market, not the personal obligations an agent owes to a specific client. C is wrong because disclosure exemptions describe situations where a duty to disclose does not apply. They are exceptions, not the bundle of loyalty and care obligations an agent owes the client. D is wrong because statutory liens are claims the law places against property for unpaid debts. They concern securing payment, not the trust-based obligations a broker owes the seller as a fiduciary. Every agency relationship rests on a bundle of duties the agent owes the client. So fundamental, the law calls them fiduciary. These duties define what it truly means for a broker to represent a client faithfully. The classic set, remembered by old car, includes obedience, loyalty, disclosure, confidentiality, accounting, and reasonable care. Obedience means following lawful instructions. Loyalty means putting the client first. Disclosure means sharing material facts. Confidentiality means protecting private information. Accounting means handling money accurately. And reasonable care means performing skillfully. The law imposes this fiduciary standard because the client places enormous trust in the agent and is vulnerable to the agent's superior knowledge. The agent must affirmatively advance the client's interests, not merely avoid dishonesty. Antitrust duties protect market competition. Disclosure exemptions are carve-outs from a duty rather than the duty itself. And statutory liens secure unpaid debts. None of these involve the personal trust owed from agent to principal. When a question describes following instructions, keeping secrets, accounting for funds, and putting the client first, the answer is fiduciary duties, the highest standard of trust the law recognizes. Question 19. A single individual takes title to a condominium in her name alone, with no co-owners and no survivorship arrangement. Which form of ownership best describes how she holds title? Your options are A. Tenancy in common, B. Joint tenancy, C. Tenancy by the entirety, D. Ownership in severalty. Before I reveal it, which one do you think is right? The correct answer is D. Ownership in severalty. D is correct because ownership in severalty means title is held by one person or entity alone. With no co-owners, she controls the property by herself, and at death it passes through her estate rather than to any surviving co-owner. A is wrong because tenancy in common requires two or more owners holding undivided shares. Because she is the sole owner with no one sharing title, there is no co-tenancy of any kind to describe here. B is wrong because joint tenancy needs at least two owners who share equal interest with a right of survivorship. A single owner cannot form a joint tenancy since there is no second tenant to survive to. C is wrong because tenancy by the entirety is reserved for a married couple holding as one legal unit. One unmarried individual taking title alone does not meet that requirement, so this form cannot apply. Before diving into co-ownership rules, let's isolate the simplest case, one person owning property entirely alone. Ownership in severalty means title held by a single person or entity, with the owner's interest severed from anyone else's. That owner controls the property fully, needs no one's consent, and when they die, the property passes through their estate by will or intestacy, not to a co-owner. Severalty stands apart from the three principal co-ownership forms: tenancy in common, joint tenancy, and tenancy by the entirety. Each of those requires two or more owners and carries its own survivorship and share rules that simply don't apply when there is only one owner. Picture a deed naming a single individual with no co-owners listed and no survivorship language at all. That single owner holds full title, free to sell or mortgage alone. The signal words are alone, in her name alone, and no co-owners. They rule out every shared form and point straight to severalty. Question 20. After collecting a security deposit, a Massachusetts landlord must handle the money in a particular way. How must the landlord hold the tenant's security deposit? Your options are A. In the landlord's personal account, B. As part of the landlord's operating funds, C. In a separate interest-bearing Massachusetts bank account, D. In cash kept at the property. What's your answer? commit to one before I continue. The correct answer is C, in a separate interest-bearing Massachusetts bank account. C is correct because the landlord must hold the security deposit in a separate interest-bearing account in a Massachusetts bank, kept apart from the landlord's own funds. The deposit remains the tenant's money, protected even from the landlord's creditors. Is wrong because placing the deposit in the landlord's personal account commingles the tenant's money with the landlord's own. The law requires a separate account, so mixing the funds this way is prohibited. B is wrong because treating the deposit as operating funds again blends what belongs to the tenant into the landlord's accounts. The deposit must stay in a separate interest-bearing account, not be folded into general finances. D is wrong because keeping the deposit in cash at the property fails the requirement for a separate bank account. The funds must be held in an interest-bearing Massachusetts bank account, not stored informally. A security deposit is always the tenant's money, never the landlord's, and Massachusetts law protects it with unusually strict handling rules. The landlord must hold the deposit in an account that is separate from personal funds, interest-bearing, and located at a Massachusetts bank. All three features are required together. Because the deposit is held in trust, it must stay legally separate from the landlord's own money. That separation means the interest belongs to the tenant, and the funds stay out of reach even if the landlord's creditors come calling. Only a separate interest-bearing Massachusetts bank account is compliant. Dropping the deposit into a personal account, mixing it with operating funds, or keeping it as cash on hand all count as violations of the statute. The deposit never stops being the tenant's property, so it must stay identifiable, earning interest, and shielded from the landlord's finances at all times. Question 21. With the informed written consent of both the seller and the buyer, one licensee represents both parties in the same transaction. What is this relationship called? Your options are A. Dual agency, B. Subagency, C. A facilitator relationship, D. Designated agency. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is A. Dual agency. A is correct because dual agency is when one licensee represents both the seller and the buyer in the same transaction with the informed written consent of both. The dual agent must remain neutral since fully advocating for one would harm the other. B is wrong because subagency is when a cooperating broker works for the seller through the listing broker. It represents one side, the seller, rather than both parties at once, so it is not dual agency. C is wrong because a facilitator represents neither party and owes no agency loyalty to either. Because a dual agent does represent both clients, the neutral facilitator role is different from dual agency. D is wrong because designated agency assigns separate licensees within a firm to each party, so each is fully represented. Dual agency involves one licensee for both, which is a different arrangement from designating two agents. When one agent works both sides of a sale, the law calls the special arrangement dual agency. Dual agency exists when a single licensee represents both the seller and the buyer in the same transaction. Because their goals conflict, the law requires informed written consent from both parties. And once consenting, the agent must stay strictly neutral, keeping each side's secrets confidential. Picture one agent standing between the seller and the buyer, owing fiduciary duty to both sides at once. That single point of loyalty is exactly what forces the agent into a neutral, impartial role instead of an advocate for either party. Don't confuse dual agency with its neighbors. Subagency represents only the seller. A facilitator represents neither party. Designated agency uses two separate licensees for full individual representation. and dual agency alone puts one licensee on both sides. Remember the tell, one licensee, both parties and written consent. That combination means dual agency. Question 22. A federal law makes it illegal for a lender to deny credit or set different terms based on a borrower's race, religion, sex, marital status, age, or receipt of public assistance. Which law is this? Your options are A. The Truth in Lending Act, B. The Equal Credit Opportunity Act, C. The Real Estate Settlement Procedures Act, D. The Home Inspection Act. Which would you go with? Lock it in before the reveal. The correct answer is B. The Equal Credit Opportunity Act. B is correct because the Equal Credit Opportunity Act prohibits lenders from discriminating in any part of a credit transaction based on protected characteristics such as race, sex, marital status, age, or receipt of public assistance. It ensures fair access to credit. A is wrong because the Truth in Lending Act requires disclosure of the cost of credit. It helps borrowers compare loan terms but does not address discrimination in deciding whether to extend credit. C is wrong because the Real Estate Settlement Procedures Act bans kickbacks and requires settlement cost disclosure. It regulates closing practices, not discrimination, in a lender's decision to grant credit to an applicant. D is wrong because there is no general Home Inspection Act governing credit. Inspection rules concern property condition, not whether a lender may treat applicants differently based on protected traits when extending credit. Before someone can even reach a landlord or seller, they must first secure financing, and federal law makes sure that step is fair too. That protection comes from a law separate from fair housing itself. The Equal Credit Opportunity Act bars creditors from discriminating based on race, religion, sex, marital status, age, or the fact that income comes from public assistance. It covers the entire credit decision from whether to lend at all to the terms offered. 3 federal laws often get confused. The Equal Credit Opportunity Act bars discriminatory lending decisions. The Truth in Lending Act just requires disclosure of credit costs like the APR, and the Real Estate Settlement Procedures Act governs closing costs and kickbacks, not discrimination at all. Picture a single credit transaction, an applicant, a creditor, and the lending decision where credit is granted or denied and terms are set. That decision must rest only on credit worthiness, never on protected characteristics like marital status, age, or the source of someone's income. When the harm is a lender treating an applicant differently because of who they are, the answer is the Equal Credit Opportunity Act, the federal guarantee of non-discriminatory access to credit. Question 23. While investigating a complaint against a broker, the board needs to review the broker's transaction and escrow records. What authority does the board have over those records? Your options are A. It may never see private records. B. It needs the broker's permission. C. It must first obtain a search warrant. D. It may examine the required records. Don't overthink it. Which one feels right? The correct answer is D. It may examine the required records. D is correct because the board has authority to examine a licensee's required transaction and escrow records, which are subject to inspection. This power lets the board verify compliance and investigate complaints, and refusing to permit inspection is itself a violation. A is wrong because the board is not barred from reviewing a licensee's records at all. The required transaction and escrow records are subject to the board's inspection as part of its authority to oversee and discipline licensees. B is wrong because the broker's permission is not a precondition to the board's review. because the records are made subject to board inspection by the rules. The board may examine them without first obtaining the licensee's consent. C is wrong because a search warrant is not required for the board to inspect a licensee's required records. The licensing rules make those records subject to inspection, so the board may examine them directly when investigating. Regulatory boards need direct access to the records they oversee, or they can't do their job. This is the theory behind the board's power to inspect a licensee's files. The board can examine two kinds of required records: transaction records, showing every deal a licensee handled, and escrow records, showing client funds held in trust. These exist so the board can verify compliance and investigate complaints. The exam trap is assuming inspection needs a precondition. In truth, the board doesn't need the licensee's permission, doesn't need a warrant, and isn't barred from reviewing at all. Because holding a license means accepting inspection as a condition, the broker's records sit directly within the board's authority, ready for review whenever a complaint arises. Refusing inspection isn't a shield, it's a separate violation. Holding a license means accepting an open book obligation to the board. Question 24. A person openly, continuously, and without permission uses a path across a neighbor's land for the full statutory period and gains a legal right to keep using it. How was that right acquired? Your options are A, by express grant, B, by prescription, C, by necessity, D, by estoppel. Got a guess? Lock it in. The correct answer is B, by prescription. B is correct because an easement by prescription arises from open, continuous, and adverse use that lasts the statutory period without the owner's permission. The hostile, visible use over the required years ripens into a lasting right to continue. A is wrong because an express grant is created by a written, signed document deliberately conveying the easement. This right grew out of long unauthorized use rather than any deed, so it was not granted in writing. C is wrong because an easement by necessity arises when a parcel would otherwise be landlocked, usually after a single parcel is divided. The facts describe years of adverse use, not a division leaving land without access. D is wrong because easement by estoppel depends on one party reasonably relying on another's permission or representation. Here the use was adverse and unpermitted, so reliance on the owner's conduct is not what created the right. Land can gain a right of use over time simply through the way it's used, not through a signed document. The clearest example is a right-of-way that ripens from years of open, unpermitted crossing. The doctrine requires four things. The use must be open, continuous, adverse, and maintained for the full statutory period. Adverse is the key word. It means used without the owner's permission as of right, rather than by invitation. Picture a landowner walking and driving across a strip of her neighbor's land to reach a backfield, openly and regularly, year after year, without ever asking permission. Once that pattern continues for the full statutory period, the law converts it into a lasting legal right to keep using the path. The exam wants you to match each easement to its trigger. A grant comes from a deed. Necessity comes from a landlocked division. Estoppel comes from relying on someone's permission or representation. And prescription alone comes from open, continuous, adverse use. Permission is fatal to a prescriptive claim because permitted use can never be adverse. If the neighbor had simply said yes at the start, no prescriptive easement could ever form. Question 25. An older Massachusetts homeowner wants to convert home equity into payments through a reverse mortgage. Before the loan can proceed, what does state law require the borrower to complete? Your options are A, counseling from an approved agency, B, a second appraisal, C, a new home inspection, D. A title insurance waiver. Which one is it? Pause the video if you need more time. The correct answer is A. Counseling from an approved agency. A is correct because Massachusetts requires a reverse mortgage borrower to complete counseling from an approved third-party agency before the loan proceeds. A reverse mortgage made without the required counseling is unenforceable, protecting older owners from misunderstanding the product. B is wrong because a second appraisal is not the safeguard the law imposes on reverse mortgages. The required protection is independent counseling about the loan, not an additional valuation of the property. C is wrong because a new home inspection examines physical condition and is not the reverse mortgage prerequisite. State law conditions these loans on borrower counseling, not on an inspection of the house. D is wrong because waiving title insurance is neither required nor wise, and it is unrelated to reverse mortgages. The mandated step is counseling from an approved agency so the borrower understands the loan. A reverse mortgage lets older homeowners turn home equity into cash without selling. But before that loan can proceed in Massachusetts, the law demands one specific safeguard. In a reverse mortgage, the lender pays the borrower over time, drawing down the home's equity instead of building it. The loan is repaid later, when the borrower sells, moves out, or dies, so the cash flow runs backward compared to an ordinary mortgage. This backward flow of money creates real risk. Accruing interest and fees can quietly consume the equity that would otherwise pass to heirs. Because the mechanics are so easy to misunderstand, Massachusetts requires independent counseling from an approved agency before the loan can close. The nuance to remember is that counseling, not a second appraisal, a new home inspection, or waiving title insurance, is the required step. Those other procedures address the property. Counseling addresses whether the borrower actually understands the loan. Skip the counseling, and the reverse mortgage becomes unenforceable, a rule designed to protect the borrower's understanding, not the property's value. Question 26. An owner and a property manager sign a contract setting out the manager's authority, duties, compensation, and the term of the engagement. What is this contract called? Your options are a listing agreement, B, a purchase and sale agreement, C, a property management agreement, D, a proprietary lease. Take a second. Which answer would you pick? The correct answer is C, a property management agreement. C is correct because a property management agreement is the contract that sets out the manager's authority, duties, compensation, and term. It establishes the general agency between the owner and the manager and defines how the property will be operated. A is wrong because a listing agreement employs a broker to market a property for sale. It concerns selling, not the ongoing operation of a rental property under a manager's care. So it does not describe this contract. B is wrong because a purchase and sale agreement transfers ownership between a buyer and seller. It governs a sale rather than the engagement of a manager to run a property, so it is the wrong document. D is wrong because a proprietary lease lets a cooperative shareholder occupy a unit owned by the corporation. It belongs to cooperative housing, not to the arrangement hiring a manager to operate rental property. Every property management relationship begins with a contract, and knowing exactly which contract applies is a core skill tested on the exam. A property management agreement spells out 4 essential elements: the manager's authority to act, the duties they must perform, the compensation they'll receive, and the term of the engagement. This agreement creates a general agency because the manager repeatedly acts on the owner's behalf over time rather than handling just one transaction. It's easy to confuse this with other real estate documents, but each serves a different purpose. The property management agreement covers ongoing operation. A listing agreement covers marketing a sale. A purchase and sale agreement covers transferring ownership. And a proprietary lease covers occupying a co-op unit. Remember the signal: authority, duties, compensation, and term point to a property management agreement, governing operation, not selling, and not occupying. Question 27. A buyer expects to gain ownership the moment a sales contract is signed, but learns that ownership actually transfers later when the deed is delivered. Until then, the seller still holds what? Your options are A. Equitable title only. B. No interest at all. C. A leasehold estate. D. Legal title. Before I reveal it, which one do you think is right? The correct answer is D. Legal title. D is correct because until the deed is delivered at closing, the seller retains legal title while the buyer under a signed contract holds equitable title. Ownership formally transfers when the deed passes, not when the contract is signed. A is wrong because equitable title is what the buyer gains under a signed purchase contract, not what the seller keeps. The seller continues to hold legal title until the deed is delivered, so this answer reverses the parties. B is wrong because the seller plainly retains an interest before closing since he still owns the property. Saying he holds no interest ignores that legal title remains with him until the deed transfers it to the buyer. C is wrong because a leasehold is a tenant's possessory interest under a landlord. The seller is an owner awaiting closing, not a tenant, so describing his remaining interest as a leasehold misstates his position. A signed purchase contract feels like ownership, but the law sees something more nuanced happening in the gap between signing and closing. Until the deed is delivered, the seller keeps legal title, the formal record of ownership, while the buyer holds equitable title, the enforcery right to complete the purchase. This split is created by the doctrine of equitable conversion. Picture this single bundle of ownership rights dividing the moment a valid contract is signed. The seller retains legal title, the buyer gains equitable title, and at closing, when the deed is delivered, the two interests merge back together in the buyer. So who holds what? The seller keeps legal title, the buyer holds equitable title, and importantly, neither party is a tenant. The seller is still an owner, not someone with a mere leasehold. Remember, signing a contract creates an equitable interest, but legal ownership only passes when the deed is delivered at closing. Question 28. A law requires that contracts for the sale of land be in writing and signed by the party to be charged in order to be enforced in court. Which legal doctrine imposes this requirement? Your options are A. The paroled evidence rule. B. The doctrine of laches. C. The statute of frauds. D. The doctrine of merger. What's your answer? Commit to one before I continue. The correct answer is C. The statute of frauds. C is correct because the statute of frauds requires that contracts for the sale of land be in writing and signed by the party to be charged. Its purpose is to prevent fraud and false claims about important agreements concerning real estate. A is wrong because the parole evidence rule limits using outside statements to change a written contract's terms. It governs evidence about an existing writing, not whether a land contract must be in writing at all. B is wrong because the doctrine of lacus bars a claim brought after an unreasonable, prejudicial delay. It is an equitable defense about timing, not the rule requiring land contracts to be written and signed. D is wrong because the doctrine of merger blends a lesser estate into a greater one held by the same person. It addresses how estates combine and has nothing to do with the writing requirement for land sales. Some contracts are too important to rest on spoken promises alone. That's the idea behind the statute of frauds. The statute of frauds requires certain contracts, including land sale contracts, to be in writing and signed by the party to be charged before a court will enforce them. Its purpose is to prevent fraud and perjury by demanding reliable written proof instead of accepting an oral claim on its own. Picture a buyer and seller negotiating the sale of a house. Only when the party to be charged signs a written contract does the agreement become enforceable in court. Exam questions often try to confuse the statute of frauds with three other doctrines: the parole evidence rule, which governs interpreting an existing writing; laches, which bars stale claims after unreasonable delay; and merger, which blends a lesser estate into a greater one. Only the statute of frauds asks whether a land contract must be written and signed at all. Remember, land sale contracts need a signed writing to hold up in court. That threshold question is what makes this doctrine unique. Question 29. A well-kept home loses value after a noisy highway is built next to the neighborhood, a condition the owner cannot change. Which type of depreciation is this? Your options are A. Functional obsolescence, B. External obsolescence, C. Physical deterioration, D. Curable depreciation. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is B. External obsolescence. B is correct because external obsolescence is a loss in value caused by negative influence outside the property boundaries, such as a new highway. Because the owner cannot fix conditions off the site, this form of depreciation is considered incurable. A is wrong because functional obsolescence arises from outdated design or features within the property itself. The home is well kept and the harm comes from outside, so the cause is external rather than functional. C is wrong because physical deterioration is value lost to wear and aging of the structure. The house is in good condition, its value fell because of a nearby nuisance, not because its own materials broke down. D is wrong because curable depreciation describes a defect worth repairing because the fix adds at least its cost. A highway beyond the owner's control cannot be cured by the owner, so this label does not fit. Property can lose value for reasons that have nothing to do with the building's own condition, and appraisers have a special category for this: external obsolescence. Depreciation in appraisal is loss in value from any cause, and it splits into three categories: physical deterioration, functional obsolescence, and external obsolescence. Physical deterioration and functional obsolescence both originate inside the property and are often curable through repair or redesign. External obsolescence alone originates outside the property, from forces like a highway, a nearby factory, or a weak local economy, and it is incurable because the owner has no control over it. Picture a well-kept home in a pleasant neighborhood. The roof is sound and the floor plan works fine. Yet its value drops once a noisy highway is built alongside it. The house didn't change, but the surrounding area did. Whenever a stem describes a sound, well-kept property losing value because of something beyond its boundaries that the owner cannot change. The answer is external obsolescence. Question 30. A seller hires a broker for the limited purpose of finding a buyer for one specific property in a single transaction. The broker has authority only for that task. Which kind of agent is the broker? Your options are A. A special agent, B. A general agent, C. A universal agent, D. A gratuitous agent. Which would you go with? Lock it in before the reveal. The correct answer is A. A special agent. A is correct because a special agent is hired for a single task or transaction with limited authority. A broker engaged to sell one specific property acts as a special agent, empowered only to carry out that particular assignment. B is wrong because a general agent has authority over a continuing series of matters, like a property manager handling a building. The broker here is limited to one sale, which is the narrower role of a special agent. C is wrong because a universal agent holds broad authority to act in all of the principal's affairs. Selling one property is far narrower than that sweeping power, so the broker is a special, not universal, agent. D is wrong because a gratuitous agent is one who acts without compensation. The classification turns on payment, not scope, so it does not describe a broker hired for the single task of selling a property. Agents differ not in importance but in how much authority they hold. Agency law sorts them into categories by that breadth, starting with the narrowest one, the special agent. A special agent is hired for a single task or transaction, like a broker engaged to sell one property. Their power is confined to that one assignment and goes no further. Picture the broker's authority as a boundary drawn tightly around one property. The principal grants power only to market and sell that specific asset. Nothing outside it. The exam tests this against three other categories. The special agent handles one task. The general agent manages a continuing series of matters. The universal agent holds broad power over all affairs. And the gratuitous agent is defined not by scope but by serving without pay. Match the authority to the intention. A broker hired to sell one property is a special agent, because the power grant goes only that far. Question 31. A seller needs the required Title V septic inspection before a sale. Who is qualified to perform this inspection under Massachusetts rules? Your options are A. The listing real estate agent. B. Any licensed home inspector. C. A state-approved system inspector. D. The local building commissioner. Don't overthink it. Which one feels right? The correct answer is C. A state-approved system inspector. C is correct because a Title V septic inspection must be performed by a state-approved system inspector using the official form. A general home inspector or the listing agent is not qualified to conduct the specialized inspection of the septic system. A is wrong because the listing agent is not qualified to perform a Title V inspection. The rules require a state-approved system inspector, so the agent cannot stand in for that specialized professional. B is wrong because a general home inspector evaluates the overall house, but is not the approved professional for a Title V septic inspection. That inspection requires a state-approved system inspector instead. D is wrong because the building commissioner enforces the building code and does not conduct Title V septic inspections. The required inspector is a state-approved system inspector, not a municipal building official. Massachusetts law requires a septic system inspection before many property sales, but not just anyone can perform it. Title V is the state regulation governing septic system design, construction, and inspection. It requires that a state-approved system inspector complete an official inspection form before a sale closes. Several people involved in a sale might seem qualified, but aren't the listing agent, who only markets the property, the general home inspector, who evaluates the house but not septic specifics, and the building commissioner, who enforces building code. Only the state-approved system inspector may perform a Title V inspection. The septic system itself shows why this expertise matters. Wastewater flows from the house into a tank, then out to a drain field, with groundwater nearby that could be contaminated if the system fails. Remember, when a STEM asks who may perform a Title V inspection, the answer is always the state-approved system inspector. Question 32. An instructor groups agents into one for a single task. one for ongoing matters, and one with broad authority over all affairs. These categories classify agents according to what? Your options are A, by their fiduciary duties, B, by their scope of authority, C, by their commission rate, D, by their license type. Got a guess? Lock it in. The correct answer is B, by their scope of authority. B is correct because agents are classified by scope of authority into special, general, and universal agents. A special agent handles one task, a general agent manages ongoing matters, and a universal agent holds broad authority over the principal's affairs. A is wrong because fiduciary duties describe what an agent owes a client, such as loyalty and disclosure. They are the same across agents and do not create the special, general, and universal categories defined by authority. C is wrong because a commission rate is the agreed fee a broker earns for services. It concerns compensation, not the breadth of authority that distinguishes special, general, and universal agents from one another. D is wrong because a license type identifies whether a person is a broker or salesperson. It governs licensing status, not the scope of authority categories used to classify agents by how much they are empowered to do. Agents aren't just agents. The law sorts them by exactly one thing: how much authority the principal has granted them. A special agent handles a single task like selling one house. A general agent manages ongoing matters like running an apartment building over time. A universal agent holds authority over all of the principal's affairs, typically under a comprehensive power of attorney. The scope is simply the breadth of power the principal hands over to the agent, and it determines exactly what the agent can commit the principal to, and how much third parties can rely on the agent's word. Don't confuse this with fiduciary duties, which stay the same across all three types, or with commission rate, which is about pay, or license type, which is about whether someone is a broker or salesperson. None of those create the special, general, universal split. Only scope of authority does. So whenever a question separates agents by single task, ongoing matters, or broad authority over all affairs, the answer is scope of authority, not duties, pay, or licensing. Question 3. A person wants to manage rental properties for various owners and collect fees for leasing the units to tenants. Under Massachusetts law, what does performing this leasing work for others generally require? Your options are a real estate license, B, a home inspector license, C, an appraiser certification, D, no license of any kind. Which one is it? Pause the video if you need more time. The correct answer is A, a real estate license. A is correct because renting or leasing real estate for others for a fee is a brokerage activity that generally requires a real estate license. Managing and leasing units for various owners falls within the licensing law unless a specific exemption applies. B is wrong because a home inspector license authorizes inspecting property condition, not leasing units for owners. Leasing real estate for others for compensation requires a real estate license, not an inspector credential. C is wrong because an appraiser certification authorizes valuing property, not renting it on behalf of owners. The leasing work described is brokerage activity that calls for a broker's license, not an appraisal credential. D is wrong because leasing for others for a fee is not license-free. Because it is a brokerage activity, it generally requires a real estate license rather than no credential at all. Whether an activity needs a real estate license comes down to one question. Is someone performing a brokerage activity for another person for compensation? Brokerage activity means performing acts like selling, buying, renting, leasing, or negotiating real estate deals for someone else in exchange for a fee. Managing rental properties and collecting leasing fees for multiple owners fits squarely within this definition. The licensing law exists to protect the public, because leasing units for owners means handling someone else's property, negotiating terms, and often handling their money. Requiring a license ensures the person has met education and exam standards and can be held accountable. The exam tests whether you match the right credential to the right activity. A home inspector license covers inspecting condition, not leasing units. An appraiser certification covers valuing property, not renting it for owners. Leasing for others for a fee is brokerage, so it calls for a real estate license, not one of these other credentials, and not no license at all. Whenever a scenario describes managing or leasing property for other owners in exchange for fees, that combination of for others and for a fee signals brokerage activity, and the answer is a real estate license. Question 34. A Massachusetts town wants to raise its total annual property tax collections far above the usual limit. A statewide law restricts how much the total levy may grow each year. Which law is this? Your options are A. The Massachusetts Zoning Act, B. The Subdivision Control Law, C. The State Sanitary Code, D. Proposition 2 1/2. Take a second. Which answer would you pick? The correct answer is D. Proposition 2 1/2. D is correct because Proposition 2 1/2 caps the total property tax levy a community may raise and limits its yearly growth. It restrains the overall levy rather than any single bill, and voters must approve an override to exceed the limit. A is wrong because the Massachusetts Zoning Act governs how cities and towns regulate land use, districts, and variances. It shapes development, not the amount of property tax a community may collect, so it does not cap the levy. B is wrong because the Subdivision Control Law sets the process for dividing land into lots with adequate access. It deals with planning board review of subdivisions and has nothing to do with limiting annual tax collections. C is wrong because the State Sanitary Code establishes minimum standards for fitness of rental housing, such as heat and water. It protects tenants and bears no relationship to the ceiling on a town's property tax levy. Massachusetts caps how much a town's total property taxes can grow each year. That cap is called Proposition 2 1/2. This law doesn't limit any single tax bill. Instead, it sets a ceiling on the total levy, restricts how much that levy can grow annually, and allows extra room for new construction, called new growth. Picture the levy as water filling a tank with a fixed ceiling. It can only rise a little each year, plus a small trickle from new growth. To break through that ceiling and collect more, the town needs an override, a vote where residents approve raising the cap themselves. Don't confuse this tax cap with other Massachusetts laws. The Zoning Act regulates land use and districts. The Subdivision Control Law governs dividing lots for development, and the State Sanitary Code sets housing fitness standards. None of these touch the property tax levy. Only Proposition 2 1/2 does. Remember, Proposition 2 1/2 caps the total levy and its growth, and only a voter-approved override can raise it beyond that limit. Question 35. Before approving a loan, an underwriter examines the borrower's income and existing debts to judge whether the borrower can afford the new payment. Which of the 3 C's is being evaluated? Your options are A. Collateral, B. Credit, C. Capacity, D. Conversion. Before I reveal it, which one do you think is right? The correct answer is C. Capacity. C is correct because capacity is the borrower's ability to repay, judged from income and existing debt obligations. By weighing earnings against debts, The underwriter measures whether the borrower can handle the new monthly payment. A is wrong because collateral refers to the property pledged to secure the loan. It addresses what backs the debt if the borrower defaults, not whether the borrower's income can support the payments. B is wrong because credit looks at the borrower's history of repaying past obligations. It reflects willingness and track record, while the analysis of income against debt measures the separate factor of capacity. D is wrong because conversion is the misuse of client funds by a fiduciary, an ethics term unrelated to underwriting. It does not name a factor an underwriter weighs when approving a borrower for a loan. Underwriters evaluate every borrower using a simple framework known as the 3 C's. Each C names a distinct factor in the lending decision. Capacity is the borrower's ability to repay. Credit is their track record of repaying. Collateral is the property pledged to secure the loan. Each answers a different question, so a sound decision requires checking all 3. To judge capacity, the underwriter compares the borrower's monthly income against existing monthly debts, then asks whether the new mortgage payment can still be afforded. This forward-looking check is the essence of the capacity analysis. Capacity asks whether income can support the payment. Credit asks how reliably the borrower has repaid in the past. Collateral asks what property backs the loan if the borrower defaults. Confusing these is the trap the exam tests. Whenever a question weighs income against existing debts to judge affordability, the answer is capacity, not credit or collateral. Question 36. Besides the first month's rent, a security deposit, and a lock and key charge, which additional payment may a Massachusetts landlord lawfully collect from a tenant at move-in? Your options are A. A non-refundable pet fee, B. The last month's rent, C. An application processing fee, D. A credit check fee. What's your answer? Commit to one before I continue. The correct answer is B. The last month's rent. B is correct because at move-in, a landlord may lawfully collect the first and last month's rent, a security deposit, and the cost of a new lock and key. Of the options listed, only the last month's rent is permitted. A is wrong because a non-refundable pet fee is not among the permitted move-in charges. Massachusetts limits move-in money to a short list and a pet fee is not on it, so it may not be collected. C is wrong because an application processing fee is not a permitted move-in charge. The lawful list does not include application fees, so charging one violates the limits on move-in money in Massachusetts. D is wrong because a credit check fee is outside the permitted charges at move-in. The landlord may not pass this cost to the tenant since it is not among the allowed move-in payments. Massachusetts law strictly limits what a landlord can collect when a tenancy begins, and the list of allowed charges is short and exclusive. Anything not on that list simply cannot be charged. At move-in, a landlord may lawfully collect only 4 things: the first month's rent, the last month's rent, a security deposit, and the cost of a new lock and key. Nothing beyond these 4 is permitted, no matter how ordinary another fee might sound. Picture a single rental unit at move-in, with each lawful charge attached to it like a label: first month's rent, last month's rent, security deposit, and lock and key cost. These 4 labels are the entire lawful transaction. Nothing else may be attached. A non-refundable pet fee, an application processing fee, and a credit check fee are not on that list, so none of them may be collected at move-in, regardless of how reasonable they sound. The exclusivity is the whole point. The last month's rent is lawful because it's on the list, while pet, application, and credit check fees are not, protecting tenants when they're most financially vulnerable. Question 37. A grantor wants to transfer whatever interest he may have in a parcel without making any promises or warranties about the title at all. Which deed accomplishes this with no covenants? Your options are A release deed. B. A general warranty deed. C. A Massachusetts quitclaim deed. D. A bargain and sale deed with covenants. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is A. A release deed. A is correct because a release deed conveys only whatever interest the grantor holds, with no covenants or warranties of title. It is the instrument used when the grantor will make no promises at all about the quality of the title. B is wrong because a general warranty deed makes the strongest title promises, defending against all claims. Because the grantor wants to give no warranties, this fully protective deed is the opposite of what is needed here. C is wrong because a Massachusetts quitclaim deed still carries limited covenants against the grantor's own acts. Since the grantor wishes to make no promises whatsoever, the covenant-free release deed fits better than the quitclaim does. D is wrong because a bargain and sale deed with covenants includes some assurances of title. Adding covenants is exactly what the grantor wants to avoid. So this deed does not match the goal of conveying without any warranty. Deeds differ mainly in the promises a grantor makes about the title being conveyed. At one extreme sits a deed that makes no promises at all, and understanding that spectrum is the key to this concept. A deed is the legal instrument that conveys real property from grantor to grantee. Covenants of title are the grantor's promises about that title, like owning the property and defending the grantee against claims, and deeds vary in how many of these promises they carry. A general warranty deed promises the most, defending against all claims. A bargain and sale deed with covenants promises some assurances. A Massachusetts quitclaim deed promises only against the grantor's own acts, and a release deed promises nothing at all. Picture a grantor handing over whatever interest he holds through a release deed with no covenants attached. The grantee receives only that interest, and if the title later proves defective, there is no warranty to sue on. When a grantor conveys whatever interest he may have and promises nothing about the title, that covenant-free instrument is the release deed, a step beyond even the limited protection of a Massachusetts quitclaim. Question 38. An instructor explains that for a property to have value, it must be desired, useful, limited in supply, and capable of being transferred. Which set of elements is being described? Your options are A. The three approaches to value. B. The four unities of title. C. The covenants of a deed. D. Demand, utility, scarcity, transferability. Which would you go with? Lock it in before the reveal. The correct answer is D. Demand, utility, scarcity, transferability. D is correct because demand, utility, scarcity, and transferability are the four elements that must combine for a property to hold value. If anyone is missing, value cannot exist, which is why each element is essential. A is wrong because the three approaches to value are the sales comparison, cost, and income methods an appraiser uses. They are techniques for estimating value, not the underlying elements that cause a property to have value at all. B is wrong because the four unities of time, title, interest, and possession describe how a joint tenancy is created. They concern a form of co-ownership and have nothing to do with the forces that give a property value. C is wrong because the covenants of a deed are the warranties a grantor makes about title, such as seisin and quiet enjoyment. They address the quality of ownership transferred, not the elements that create value. Real estate value doesn't just happen automatically. It requires four conditions to combine at once, a framework appraisers remember by the acronym DUST. Demand is desire backed by ability to pay. Utility is usefulness. Scarcity means limited supply. And transferability means ownership can actually be conveyed from one party to another. Picture a single parcel of land with all four conditions attached to it at once. Remove any one call-out say transferability, and the parcel's value disappears no matter how desirable, useful, or scarce it remains. Don't confuse dust with similar sounding frameworks. The 3 approaches to value measure worth. The 4 unities describe how joint tenancy is created, and deed covenants warrant title. None of these create value the way demand, utility, scarcity, and transferability do. Demand, utility, scarcity, and transferability are the prerequisites for value itself, all 4 required together, distinct from how value is appraised or how co-owners hold title. Question 39. A property carries a recorded first mortgage, a later judgment lien, and unpaid municipal real estate taxes. When the property is sold to satisfy debts, which claim generally holds the highest priority? Your options are A, the first mortgage, B, the real estate tax lien, C, the judgment lien, D, whichever recorded first. Don't overthink it. Which one feels right? The correct answer is B, the real estate tax lien. B is correct because real estate tax and municipal liens generally take priority over private liens regardless of recording order. The government's claim for property taxes is paid ahead of the mortgage and the judgment when the property is sold. A is wrong because a first mortgage outranks later private liens, but it still yields to municipal tax claims. Because property taxes are paid before private encumbrances, the mortgage does not hold the top position here. C is wrong because a judgment lien is a general lien that attaches when recorded and falls behind both the tax claim and the earlier mortgage. It is among the last to be paid, not the first in line. D is wrong because ordinary private liens do follow a first in time, first in right order, but tax liens are a statutory exception. The municipal tax claim jumps ahead even of earlier recorded private liens, so recording order does not control here. Every forced sale must decide who gets paid first when several liens claim the same property. Let's look at the rule that normally decides this order and the powerful exception that overrides it. Most private liens follow the rule of first in time, first in right. Whichever lien was recorded earliest gets paid before one recorded later. That's how a first mortgage normally outranks a later judgment lien. But government tax claims break this pattern. A municipal real estate tax lien attaches to the property just like a mortgage or judgment lien, yet it carries a special super priority that private liens don't have. Picture a property with a recorded first mortgage, a later judgment lien, and unpaid municipal taxes. At sale, the tax lien is paid first, the mortgage second as a senior private lien, and the judgment lien last, no matter when the tax is accrued. Recording order controls only among private liens. The government's tax claim always sits above them. That's why an unpaid tax lien can outrank even an earlier recorded mortgage. Question 40. When a Massachusetts landlord takes a security deposit, the landlord must give the tenant a written record of the apartment's condition at the start of the tenancy. What is this document called? Your options are a statement of condition, B, a municipal lien certificate, C, a notice to quit, D, a certificate of occupancy. Got a guess? Lock it in. The correct answer is A, a statement of condition. A is correct because a statement of condition is the written record of the apartment's condition at the start of the tenancy. A landlord taking a security deposit must provide it at receipt or shortly after the tenancy begins. B is wrong because a municipal lien certificate reports unpaid taxes on a property. It is a closing-related document about municipal charges, not the move-in condition record tied to a security deposit. C is wrong because a notice to quit is a document ending a tenancy or demanding possession. It belongs to the eviction process, not to the start of tenancy condition record required with the deposit. D is wrong because a certificate of occupancy confirms a building may be occupied after construction. It addresses code compliance, not the condition of a rental unit when a tenant moves in with a deposit. When a landlord collects a security deposit, Massachusetts law requires a written record of the unit's condition at move-in. That document is called the Statement of Condition. A statement of condition documents the apartment as it looks when the tenant takes possession. The landlord must hand it over at the time of the deposit or soon after the tenancy starts, and it becomes the fixed baseline both sides can point to later. Picture the moment the deposit changes hands. The landlord hands the tenant this written record of the unit's condition. That record becomes the fixed point of comparison when the tenancy ends and the unit's condition is checked again. Exams test whether you can separate this from look-alike documents. The municipal lien certificate reports unpaid taxes at closing. The notice to quit ends a tenancy, and the certificate of occupancy confirms code compliance for a building. None of these describe a unit's condition at move-in tied to a deposit. Whenever a STEM pairs a security deposit with a written record of condition at the start of a tenancy, the answer is the statement of condition, the baseline that protects both landlord and tenant. Question 41. A Massachusetts law targets high-cost home mortgage loans and, among other protections, generally bars lenders from imposing prepayment penalties on those loans. This law is best described as addressing what? Your options are A. Truth in lending disclosures, B. Fair housing and lending, C. Settlement cost kickbacks, D. Predatory home loan practices. Which one is it? Pause the video if you need more time. The correct answer is D. Predatory home loan practices. D is correct because the Massachusetts predatory home loan law restricts abusive, high-cost mortgage terms, generally barring prepayment penalties on those loans. It protects vulnerable borrowers from features that trap them in costly debt, and violations also reach the Consumer Protection Statute. A is wrong because truth in lending governs disclosure of the cost of credit. It requires clear loan information but does not ban prepayment penalties on high-cost loans the way the predatory lending law does. B is wrong because fair housing in lending prohibits discrimination based on protected characteristics. It addresses biased treatment of applicants, not the abusive loan terms and prepayment penalties the predatory lending law restricts. C is wrong because settlement cost kickbacks are governed by the law against paying for referrals. That concerns hidden referral fees among settlement providers, not the high-cost loan features and prepayment penalties addressed here. Massachusetts has a specific law that targets predatory lending in high-cost home mortgages, restricting the abusive terms that trap borrowers in costly debt. This law restricts abusive high-cost mortgage terms, generally barring prepayment penalties, so borrowers can refinance or pay off their debt without a punitive fee blocking the way out. Picture a prepayment penalty as a lock on a high-cost loan, trapping the borrower and blocking any escape to a cheaper loan. The predatory lending law removes that lock, freeing the borrower to refinance or pay off the debt early. Don't confuse this with other lending laws. Truth in lending requires cost disclosure, fair housing bars discrimination, and the kickback law targets referral fees. Only the predatory lending law restricts abusive high-cost terms and prepayment penalties. When you see high-cost home loans and barred prepayment penalties, think predatory lending law, the protection against being trapped in costly debt. Question 42. A recent Massachusetts law requires certain communities served by public transit to create at least one district where multifamily housing is allowed as of right near a transit station. Which requirement is this? Your options are A. Chapter 40B comprehensive permits, B. The subdivision control law, C. MBTA communities zoning, D. Proposition 2 and 1/2. Take a second. Which answer would you pick? The correct answer is C. MBTA community zoning. C is correct because the MBTA communities requirement directs transit-served municipalities to zone at least one district where multifamily housing is permitted as of right near a transit station. It aims to expand housing supply close to public transportation. A is wrong because Chapter 40B lets an affordable housing developer seek a comprehensive permit where a town is under the affordable threshold. It works project by project and does not require towns to pre-zone multifamily districts near transit. B is wrong because the subdivision control law addresses how land is divided into lots with adequate access. It does not compel communities to allow multifamily housing near transit, so it is unrelated to this requirement. D is wrong because Proposition 2 and 1/2 limits the growth of property tax levies. It is a tax measure and imposes no obligation to create multifamily zoning districts around transit stations. Massachusetts faces a chronic housing shortage, and one recent law stands out for tackling it directly: the MBTA communities requirement. This law requires transit-served municipalities to create at least one zoning district where multifamily housing is allowed as of right near a transit station. As of right means no special permit or discretionary approval is needed, so developers can build without extra hurdles, encouraging denser housing where transit access is strong. Picture a transit station surrounded by a zoning district where multifamily housing is automatically permitted, letting developers build dense housing close to public transportation. It's easy to confuse this with other Massachusetts land use tools. Chapter 40B allows project-by-project comprehensive permits for affordable housing. The subdivision control law governs how land is divided into lots, and Proposition 2 and 1/2 simply caps property tax levies. Only the MBTA communities requirement mandates as-of-right multifamily zoning near transit. Whenever a question describes communities served by transit required to zone as-of-right multifamily housing near a station, the answer is the MBTA communities requirement. Question 43. The Massachusetts board that regulates real estate licensees is composed of members appointed to represent both the industry and the public. How many members make up this board? Your options are A. 3 members, B. 5 members, C. 9 members, D. 12 members. Before I reveal it, which one do you think is right? The correct answer is B. 5 members. B is correct because the board is composed of 5 members, including licensed brokers from the industry and members representing the public. This mix balances professional expertise with public oversight in regulating real estate licensees across the state. A is wrong because 3 members is too few for this board. The board that regulates Massachusetts real estate licensees is made up of 5 members, combining industry brokers and public representatives, rather than only 3. C is wrong because 9 members overstates the size of the board considerably. Massachusetts sets the membership at 5, mixing industry brokers with public representatives. So a figure of 9 does not match the law. D is wrong because 12 members is well beyond the actual size of the board. The board consists of 5 members drawn from the industry and the public, so a figure of 12 is far too high. Massachusetts regulates real estate licensees through a board built to balance 2 interests: the expertise of the industry and the perspective of the public. The Board of Registration of Real Estate Brokers and Salespersons has exactly 5 members, combining licensed brokers with public representatives, so the board reflects both professional knowledge and outside accountability. Picture the board as 5 seats, some filled by brokers who understand daily practice, others by public members who keep the focus on consumer protection, together handling licensing, rulemaking, and discipline. Exam distractors play with the number. 3 understates the board size, while 9 and 12 overstate it considerably. The real figure is 5, so knowing this lets you rule out every other tempting option. Whenever a question asks about the size of the Massachusetts Real Estate Board, the answer is 5 members, a deliberately small mix of industry brokers and public representatives. Question 44. An owner holds a recorded right to cross a neighbor's driveway to reach her own landlocked lot, and the right passes to whoever later owns her lot. Which interest does she hold? Your options are A. An easement in gross, B. A license, C. An easement appurtenant, D. An encroachment. What's your answer? Commit to one before I continue. The correct answer is C. An easement appurtenant. C is correct because an easement appurtenant benefits a particular parcel, the dominant estate, and burdens the neighboring servient estate. Because the right serves her lot and passes to future owners of that lot, it is appurtenant to the land. A is wrong because an easement in gross benefits a person or company rather than a parcel, like a utilities line. Here the right belongs to the lot and transfers with it, which is the hallmark of an appurtenant easement instead. B is wrong because a license is revocable permission that does not run with the land and ends at the owner's choosing. This right is recorded and passes to later owners, so it is a durable easement, not a mere license. D is wrong because an encroachment is an unauthorized intrusion, such as a fence built over a boundary line. The owner has a lawful, recorded right to cross, which is the opposite of a trespassing structure. Easements come in different flavors depending on who benefits from them, and that difference decides whether the right survives a sale. Let's look at the type that permanently attaches to land itself. An easement appurtenant benefits one parcel of land, called the dominant estate, while burdening a neighboring parcel, called the servient estate, because the right is attached to the dominant land itself. It passes automatically to whoever owns that parcel next. Picture a landlocked lot with no direct road access, only a recorded right to cross the neighbor's driveway. That crossing right is tied permanently to the landlocked parcel, so any future owner inherits it along with the land. Don't confuse this with 3 lookalikes. An easement in gross benefits a person or company, not a parcel, like a utility line. A license is mere revocable permission, and an encroachment is an unauthorized trespass. Only the easement appurtenant attaches to a benefited parcel and passes with it. Whenever a right to cross land benefits a specific parcel and transfers automatically to future owners, that's the signature of an easement appurtenant. Question 45. A listing broker receives several written offers on a seller's home, including some below the asking price. Under Massachusetts rules, what must the broker do with these offers? Your options are A. Convey all offers promptly to the seller. B. Present only the highest offer. C. Screen out the low offers first. D. Hold the offers until the deadline. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is A. Convey all offers promptly to the seller. A is correct because a broker must convey all offers promptly to the owner who decides which to accept. The licensee may not screen, withhold, or delay offers because the choice among them belongs to the seller, not the broker. B is wrong because presenting only the highest offer withholds the others from the seller, which the rules forbid. The seller, not the broker, decides among offers, so every offer must be delivered, not just the top one. C is wrong because screening out low offers substitutes the broker's judgment for the seller's. The owner is entitled to see all offers and decide, so a licensee may not filter them before presentation. D is wrong because holding offers until a deadline improperly delays delivery. The rules require to be prompt. Offers must be conveyed without delay so the seller can act on them in a timely way. When a listing broker receives offers on a seller's property, the broker holds them on the seller's behalf. Massachusetts rules require prompt delivery of every offer because the choice to accept or reject belongs to the seller, not the broker. This duty flows from the agency relationship and the loyalty the broker owes the seller. Since the seller can't make an informed choice about offers never seen, the rules require every offer to reach the seller promptly, preserving the seller's rightful decision. Several tempting shortcuts all break this rule. Presenting only the highest offer withholds the rest. Screening out low offers substitutes the broker's judgment for the seller's. And holding offers until a self-imposed deadline improperly delays delivery. Picture the agency relationship itself. The broker is the agent, bound by fiduciary duties of loyalty and disclosure, while the seller is the principal who alone holds the authority to decide among offers. The broker's role is to present, the seller's role is to decide. Whenever multiple offers arrive, including ones below asking price, the broker's duty is simple. Deliver every offer promptly and let the seller decide. The broker presents, the seller decides. Question 46. A lender compares the amount of a loan to the appraised value of the property securing it, expressed as a ratio. What is this ratio called? Your options are A, the debt-to-income ratio, B, the capitalization rate, C, the gross rent multiplier, D, the loan-to-value ratio. Which would you go with? Lock it in before the reveal. The correct answer is D, the loan-to-value ratio. D is correct because the loan-to-value ratio compares the loan amount to the property's appraised value. Lenders use it to gauge risk, since a higher ratio means a smaller borrower down payment and less cushion if the loan defaults. A is wrong because the debt-to-income ratio compares a borrower's monthly debts to monthly income. It measures the borrower's capacity to repay, not the relationship between the loan amount and the property's value. B is wrong because a capitalization rate relates a property's net income to its value for investment analysis. It evaluates income property, not the ratio of a loan to the value of the collateral. C is wrong because a gross rent multiplier relates a property's price to its rental income. It is a valuation shortcut for rentals, not a measure comparing a loan amount to the property's appraised value. Lenders need a quick way to measure how risky a mortgage is compared to the property backing it. That measure is the loan-to-value ratio. The loan-to-value ratio compares the loan amount to the property's appraised value, expressed as a percentage. A higher ratio means less down payment and loss cushion for the lender if the home must be sold. A lower ratio means more equity protecting the loan, and very high ratios often require mortgage insurance. Picture the appraised value of a home split between the loan and the borrower's equity. The bigger the loan slice compared to the equity slice, the higher the loan-to-value ratio, and the thinner the cushion protecting the lender if the property must be sold. Don't confuse loan-to-value with look-alike ratios. Debt-to-income compares a borrower's debts to income. Capitalization rate relates a property's net operating income to its value, and the gross rent multiplier relates price to rental income. Only loan-to-value compares the loan itself to the property's appraised value. Whenever a question pairs the loan amount with the property's appraised value, the answer is the loan-to-value ratio, the lender's core gauge of collateral risk. Question 47. A downtown landowner wants to sell the right to build above her building while keeping the ground level structure. Which property right is she conveying? Your options are A, air rights, B, riparian rights, C, subsurface rights, D, littoral rights. Don't overthink it. Which one feels right? The correct answer is A, air rights. A is correct because air rights are the rights to use and control the space above a parcel. An owner may sell or lease the development potential above her building while keeping the ground level improvements because the airspace can be conveyed separately. B is wrong because riparian rights concern the use of water in a stream or river bordering the land. They have nothing to do with building in the airspace overhead, so this water-based right does not describe the transfer. C is wrong because subsurface rights involve what lies beneath the surface, such as minerals or water below ground. The owner is selling the space above the building, which is the opposite direction from these underground rights. D is wrong because literal rights attached to land bordering a sea, lake, or other large body of water. They govern shoreline use, not the airspace above a downtown building, so this right is unrelated to the sale. Land ownership isn't limited to the surface. It stretches upward into the sky and downward into the earth, and each layer can be bought, sold, or leased on its own. Air rights are the right to control and develop the space above a parcel of land. An owner can keep her building at ground level while selling the overhead development potential to someone who wants to build higher, turning unused vertical space into real economic value. Picture one parcel sliced into layers, airspace above, the surface where the building stands, and the subsurface below. Each one is separate, independently transferable interests. Don't confuse air rights with the other directional rights. Subsurface rights govern minerals below ground, riparian rights govern water bordering a stream or river, and literal rights govern land bordering a sea or lake. Only air rights point upward toward the space above the parcel. When a question describes selling the rights to build above an existing structure while keeping the ground floor, think air rights, the upward dimension of property ownership. Question 48. After discovering the seller committed fraud, a buyer asks a court to cancel the contract and return both parties to the positions they held before signing. Which remedy is the buyer seeking? Your options are A. Specific performance, B. Rescission, C. Liquidated damages, D. Assignment. Got a guess? Lock it in. The correct answer is B. Rescission. B is correct because rescission cancels a contract and restores the parties to their pre-contract positions. A buyer who was defrauded may rescind to undo the deal, returning what was exchanged, so neither side is bound by the tainted agreement. A is wrong because specific performance compels a party to complete the contract. The defrauded buyer wants to escape the deal, not enforce it, so this remedy runs opposite to the relief being sought. C is wrong because liquidated damages are a pre-agreed sum for a breach, often the deposit. That remedy keeps the contract framework in place to measure loss, rather than unwinding the agreement the buyer wants cancelled. D is wrong because assignment transfers a party's rights under a contract to someone else. It passes the deal along rather than cancelling it, so it does not return the buyer to the position held before signing. When a contract is tainted by fraud, the wrong party often doesn't want damages or enforcement. They want the whole deal erased. Rescission cancels the agreement and restores both sides to where they stood before signing, unwinding whatever was exchanged. It's the appropriate response whenever consent to the deal was corrupted from the start by fraud, misrepresentation, mistake, or duress. Picture a defrauded buyer. The deposit flows back to them, the property flows back to the seller, and both end up exactly where they stood before the contract existed. Don't confuse rescission with its neighbors. Specific performance compels a party to complete the deal. Liquidated damages measure a breach with a preset sum, and assignment transfers contract rights to someone else. Only rescission cancels the contract and restores prior positions. When a buyer wants the fraud-tainted deal erased and both sides return to where they began, that relief is rescission. Question 49. At closing, a borrower pays the lender an upfront fee to permanently lower the interest rate on the mortgage. Each such fee equals 1% of the loan amount. What are these fees called? Your options are A. Origination fees, B. Closing costs, C. Discount points, D. Private mortgage insurance. Which one is it? Pause the video if you need more time. The correct answer is C. Discount points. C is correct because discount points are upfront fees a borrower pays to buy down the interest rate, with each point equal to 1% of the loan amount. Paying points lowers the rate and the long-term cost of borrowing. A is wrong because an origination fee compensates the lender for processing and making the loan. It covers the lender's work rather than buying down the rate, so it does not describe a fee paid to lower the interest charged. B is wrong because closing costs are the broad collection of charges paid to complete a purchase, such as recording and title fees. They are a general category, not the specific rate-reducing fee the borrower paid. D is wrong because private mortgage insurance protects the lender when a borrower makes a small down payment. It guards against default loss rather than lowering the interest rate, so it is a different charge. Let's break down discount points, a fee that lets a borrower trade upfront cash for a permanently lower interest rate. Each discount point costs 1% of the loan amount, paid one time at closing, and it permanently lowers the interest rate. Because the reduction lasts for the life of the loan, points reward borrowers who hold their mortgage long enough for monthly savings to outweigh the upfront cost. Picture a borrower paying 2 discount points, 2% of the loan at closing. In exchange, the lender locks in a lower rate that holds for as long as the loan lasts. So the payoff depends entirely on how long the borrower keeps the mortgage. The exam often mixes discount points up with other charges. An origination fee pays the lender for processing the loan. Closing costs cover the broad bundle of expenses needed to finish the sale, and private mortgage insurance protects the lender against default. Only discount points actually lower the interest rate. Sort every fee by what it's for, and whenever a question describes buying down the rate with a percentage of loan payment, the answer is discount points. Question 50. For a fee, a seller gives a prospective buyer the exclusive right to purchase a property at a set price within 60 days. But the buyer is not obligated to buy. Which arrangement is this? Your options are A net listing, B, a right of first refusal, C, an installment contract, D, an option contract. Take a second. Which answer would you pick? The correct answer is D, an option contract. D is correct because an option contract gives the buyer the right, but not the obligation, to purchase at a set price within a stated time in exchange for consideration. The seller must keep the offer open while the buyer chooses whether to buy. A is wrong because a net listing is a prohibited Massachusetts compensation arrangement where the broker keeps any amount above a set net to the seller. It concerns how a broker is paid, not a buyer's right to purchase later. B is wrong because a right of first refusal lets a party match an offer only if the owner later decides to sell. It is conditional on the owner choosing to sell, unlike an option that fixes a price the buyer may exercise. C is wrong because an installment contract is a financing arrangement where the buyer pays over time and gets title later. It commits the buyer to purchase, unlike an option that leaves the decision entirely to the buyer. An option contract creates a deliberate asymmetry. One party is bound and the other stays completely free. The seller must hold the property at a fixed price for the whole option period, while the buyer keeps the choice to buy or walk away without penalty. The buyer, called the optionee, pays the seller the optional consideration to create the option. The buyer may then exercise the right before the deadline, forming a binding contract, or let the option lapse, in which case the seller simply keeps the fee. The exam pairs options with 3 lookalikes: a net listing, a prohibited broker compensation arrangement, a right of first refusal, which waits on the owner's decision to sell, and an installment contract, which binds the buyer to pay over time. Only the option leaves the buyer completely free. Picture a developer who pays a landowner an option fee for the exclusive right to buy a parcel at a fixed price within 60 days while testing zoning approval. If zoning clears, the developer exercises the option. If not, the developer walks away, losing only the fee, while the seller was bound the entire time. That wraps up our Massachusetts real estate Q&A session for today. If you'd like extra practice with everything we just covered, head over to our website. The link's right down in the description below. Once you're there, you'll find hundreds of free practice questions along with complete study guides, all ready and waiting for you to dive into and explore. Subscribe to catch the next part, and good luck on your exam.